Number 20, the myth that a VPN makes you invisible. Another remarkable misconception among some local pirates is that using a VPN means that nobody can find them. A VPN does not make a person invisible. A VPN can conceal or alter the apparent IP address presented to a website, but it does not erase every other identifying element associated with a person's digital activity. Modern digital activity can involve Microsoft accounts, Windows licenses, Google accounts, YouTube accounts, browser information, cookies, account credentials, payment records, email addresses, device identifiers, application accounts, cloud services, IP address records, platform activity, login records, router information, and numerous other forms of digital evidence. Therefore, the belief that I have a VPN so nobody knows who I am is simply not a realistic understanding of modern digital systems. Number 21. Digital forensics can extend far beyond an IP address. A digital investigation does not necessarily depend upon identifying one IP address. Evidence can potentially exist at many different levels. There can be account information, transaction records, download histories, upload records, messages, advertisements, screenshots, device information, timestamps, cloud storage records, platform records, file metadata, payment information, venue information, and other evidence. The more extensively a person uses, distributes, or advertises pirated material, the more potential evidence can exist. The person who downloads a track privately may leave one type of evidence. The person who downloads it, distributes it, advertises it, sells it, and uses it commercially can potentially leave an enormous digital trail. Number 22. Public advertising is potentially the worst mistake. This is why publicly advertising a massive karaoke collection can be extraordinarily foolish. Imagine someone advertising over 100,000 karaoke tracks. The karaoke companies can potentially see the advertisement. They can preserve the advertisement. They can record the date. They can record the website. They can record the operator's business name. They can record the contact details. They can potentially compare the advertised catalog against their own legitimate sales records. The internet has effectively become a permanent public notice board. People should therefore think very carefully before publicly boasting about the quantity of material they possess. Number 23. AI music has changed the entire industry again. There is now another development that has fundamentally changed the copyright landscape: artificial intelligence. AI music companies require enormous quantities of data to train their systems. The internet contains enormous amounts of music, lyrics, videos, photographs, artwork, recordings, written material, performances, and other creative works. Consequently, online material has become an extremely valuable source of training data. This has created enormous disputes throughout the creative industries concerning scraping, copying, ingestion, licensing, and the use of copyrighted works in AI training. The issue is no longer simply someone downloaded one song. The potential issue can now be an automated system copied millions of pieces of creative content. That is an entirely different scale of problem. Number 24. Why the major record companies are paying attention. Companies such as Universal Music Group, Sony Music Entertainment, and Warner Music Group have enormous financial interests in controlling how their catalogs are reproduced, distributed, and used. The AI revolution has therefore increased the importance of controlling digital copying. If enormous quantities of copyrighted material can be scraped from online platforms and incorporated into artificial intelligence training systems without appropriate licensing or compensation, the financial implications for the music industry are enormous. This is one of the reasons why the major rights holders have an increasing interest in how platforms such as YouTube manage access, copying, and automated extraction of content. Number 25. YouTube is part of a much larger music ecosystem. YouTube is not operating in isolation. The wider music ecosystem includes YouTube, Spotify, Apple Music, Deezer, Amazon Music, record companies, music publishers, collecting societies, artists, songwriters, producers, distributors, and countless independent creators. Every unauthorized copy can potentially affect this ecosystem. If somebody can obtain a permanent unauthorized copy from YouTube and listen to it offline, there is potentially less incentive to use a legitimate streaming service. That can affect Spotify, it can affect Deezer, it can affect Apple Music, it can affect YouTube, and ultimately it affects the people who created the music. Number 26, why offline downloading can harm YouTube creators. This is particularly important for creators whose income comes from advertising. A legitimate YouTube viewer watches a video. That creates a legitimate view. The viewer may receive advertising. The creator may receive a share of the resulting revenue. The viewer watches another video. The process continues. But if someone downloads the video and subsequently watches the downloaded copy offline, that viewing may generate no corresponding YouTube advertising revenue. The creator has therefore lost the opportunity to earn from the subsequent viewing. The situation becomes even worse if the downloaded copy is then shared with other people. One unauthorized download can potentially become dozens or hundreds of offline copies. Number 27, the South African Afrikaans music problem. This is particularly frustrating for creators producing Afrikaans and South African karaoke material. A creator can spend hours creating a karaoke video. The creator may have to 1. Obtain the appropriate music, 2. Edit the audio, 3. Prepare the backing track, 4. Synchronize the lyrics, 5. Create the graphics, 6. Prepare the video, 7. Render the finished production, 8. Upload it, 9. Manage copyright claims, 10. Maintain the channel, 11. Respond to viewers, 12. And continue producing new material. Then the video can be downloaded almost immediately after publication. The downloader has done none of the work. The downloader has not paid for the production. The downloader has not spent the hours creating it. The downloader has not carried the cost of equipment and software. The downloader simply takes the finished product. Number 28, the economic effect. The economics are therefore straightforward. The legitimate creator carries the cost plus the time plus the equipment plus the software plus the production plus the licensing plus the administration. The pirate carries the cost of clicking download. That is why piracy is so damaging. The person creating the work bears the financial burden. The person taking the work receives the benefit without bearing the production cost. Number 29. Why the pirate's action can harm the creator's revenue. A legitimate YouTube video can potentially produce revenue from advertising, views, memberships, legitimate engagement, subscriptions, and other platform-supported activities. A downloaded copy can generate none of those things for the original creator if it is consumed entirely outside the legitimate platform. The creator can therefore be left with zero additional revenue from the unauthorized copy. Meanwhile, the pirate can use the material commercially. That is an extraordinary imbalance. Number 30, the irony. There is an enormous irony in the situation. The legitimate producer creates the material. The legitimate producer pays for the equipment. The legitimate producer pays for the software. The legitimate producer spends hours producing the content. The legitimate producer obtains permissions. The legitimate producer uploads it. The legitimate producer accepts the relatively small advertising income generated by legitimate views. The pirate simply takes the finished product. The creator carries the cost. The pirate takes the benefit. That is the fundamental economic problem created by digital piracy. Number 31, the false belief that piracy is invisible. The old idea that nobody will know is increasingly outdated. Modern digital activity can create records. Online purchases can create records, accounts can create records, advertisements can create records, YouTube activity can create records, payments can create records, downloads can potentially create records, devices can contain evidence, cloud services can contain evidence, communications can contain evidence, and public advertisements can remain available for years. The digital age has therefore created an unusual situation. The same technology that makes piracy easy can also make piracy easier to investigate. Number 32, the collection size problem. There is also a practical way of looking at the problem. If a karaoke operator claims to have 10 legitimate karaoke tracks, verifying 10 tracks may be straightforward. If the operator claims to have 500,000 tracks, the question becomes much larger. Where did the 500,000 tracks come from? If the operator has purchased them legitimately, there should potentially be evidence of acquisition. If the operator has obtained them through legitimate licenses, there should potentially be licensing documentation. If they were provided as promotional copies, there should potentially be evidence of that arrangement. If they were obtained through legitimate business relationships, there should potentially be documentation. A person with an enormous collection, therefore, needs to be able to explain the provenance of that collection. Number 33, the five-track principle. A karaoke producer does not necessarily need to prove every single track in a collection immediately. Suppose an operator has thousands of tracks. The producer identifies several highly distinctive productions. The producer checks its sales records. The operator does not appear as a purchaser. The operator is publicly advertising those productions. The operator is using them commercially. The operator has been warned not to download them. The operator has nevertheless been found using them. At that point, there may be sufficient information to warrant further investigation. Again, the absence of a purchase record is not automatically conclusive proof of infringement, but it can be an important evidentiary indicator when combined with other evidence. Number 34. The biggest mistake a pirate can make. The biggest mistake is often not simply downloading, it is advertising what you have downloaded. When somebody publicly announces, "We have 100,000 karaoke tracks," they have potentially told the industry exactly where to start looking. If the person then publicly advertises the venues where they perform, posts videos of their karaoke system, publishes photographs of their screen, and advertises the services they provide, they may create an even more substantial public record. The person has effectively documented his own activity. Number 35. Karaoke operators need to understand the new digital reality. The digital world is not the same as the physical CD era. You cannot automatically assume that because something is online, it is yours. You cannot assume that you can download something, it is legal to download. You cannot assume that because you purchased one digital copy, you can redistribute it. You cannot assume that a VPN makes you anonymous. You cannot assume that YouTube content is licensed for commercial karaoke use. You cannot assume that a Samro payment automatically covers every karaoke production. You cannot assume that a karaoke company has no rights merely because it does not own the underlying song. And you cannot assume that the creator will never discover what you have done. Number 36, the correct question. The correct question is not, can I technically download this? The correct question is, what rights have I actually been granted to this material? And then, am I permitted to reproduce it? Am I permitted to store it? Am I permitted to distribute it? Am I permitted to publicly perform it? Am I permitted to use it commercially? Am I permitted to modify it? Am I permitted to transfer it to another person? Am I permitted to use the producer's branding and artwork? Those are the questions that matter. The bottom line. The transition from physical music to digital music has fundamentally changed copyright enforcement and digital ownership. With a physical LP or CD, transferring the physical object meant that the original purchaser no longer possessed that particular physical object. With digital material, a person can potentially transfer a copy while retaining the original. That makes digital piracy fundamentally different. Karaoke piracy is particularly serious because karaoke productions are digitally reproducible, easily distributed, and potentially traceable. A karaoke company may not own the copyright in the underlying song. However, that does not mean the karaoke producer has no intellectual property rights. The producer can potentially have rights in the independently created production, including its graphics, artwork, logo, branding, video, synchronization, arrangement, original audio production, and other creative elements. The precise rights depend upon the actual circumstances, contracts, licenses, and applicable legislation. The fact that a karaoke production is available on YouTube does not automatically make it free for downloading, redistribution, or commercial use. YouTube provides access to content through its platform subject to its terms of service and applicable rights. The user does not automatically receive ownership of the creator's work merely by watching it. A VPN does not automatically make a person anonymous. Public advertising does not disappear simply because the advertiser later deletes it. Digital transactions do not necessarily disappear, and the modern internet can preserve an enormous amount of information concerning what people publicly claim to own and what they publicly claim to do. Authorship, intellectual property, and legal disclaimer. This document was written by Cristina Palmerim Borges on 25th of August 2026. The wording, structure, organization, observations, commentary, analysis, and opinions contained in this document constitute the author's own intellectual property. The author asserts her intellectual property rights in the original material contained herein. The opinions expressed are those of Cristina Palmerim Borges and represent her understanding, observations, and interpretation of the issues discussed as at 25th of August 2026. This document is intended for informational, educational, and discussion purposes. It is not intended to constitute legal advice, a formal legal opinion, or a definitive determination of the law applicable to any particular person, company, karaoke producer, copyright owner, venue, platform, or set of circumstances. Copyright, intellectual property, licensing, music rights, public performance, reproduction, downloading, distribution, trademarks, protection of personal information and related legal matters can involve different laws, rights, exceptions, contractual provisions, and remedies. Accordingly, nothing contained in this document should be relied upon as a substitute for professional legal advice. For further information concerning the laws discussed in this document, readers should refer directly to the official laws, regulations, government publications, court decisions, licensing agreements, and official terms and conditions applicable to the particular issue in question. For South African copyright matters, readers should consult the Copyright Act 98 of 1978 as amended, together with all applicable amendments and related legislation. The official South African government identifies the Copyright Act as legislation dealing with copyright and related matters. South African Government, Copyright Act 1978 of 1978, PSAV.ZA/documents/Copyright Act-16, April 2015-0942. South African Government, Copyright Act 98 of 1978, Personal Information Act of 2013, POPA, and the official regulations and guidance applicable to the circumstances. For YouTube-related matters, readers should consult the official YouTube terms of service, community guidelines, copyright policies, and applicable platform documentation, rather than relying upon summaries or interpretations by third parties. Nothing in this document claims ownership of legislation, government publications, court judgments, official regulations, YouTube's own terms of service, or any other material belonging to its respective copyright owners, government authorities, platforms, or issuing organizations. This document is therefore expressly identified as Cristina Palmerim Borges, 25th of August, 2026. Original written work, intellectual property, observations, analysis, and opinions of Cristina Palmerim Borges. For further information on the laws involved, refer to the official laws in question and obtain professional legal advice where appropriate. End of document.